Can you accidentally waive attorney-client privilege when dealing with the IRS? If you're under an IRS examination, audit, or criminal tax investigation, remember this. Privilege is your first line of defense and the easiest thing to lose. One forwarded email, one helpful accountant sitting in on a meeting, one careless disclosure, and your confidential criminal tax defense strategy could become the government's next exhibit at a trial. I'm David W. Klasing, a duly licensed tax attorney and CPA who's represented clients in hundreds of civil and criminal IRS and California tax matters. In today's video, I'll explain how attorney-client privilege actually works in tax controversies, how it's accidentally waived, and what practical steps you can take to protect it before it's too late. Attorney-client privilege protects confidential communications made for the purpose of getting legal advice. It does not protect the underlying facts, records, numbers, or transactions the IRS can legally subpoena or request. There's also the work product doctrine, which protects materials created in anticipation of litigation. And then there's the tax practitioner privilege under 7525. Similar to attorney-client privilege, but largely limited to non-criminal federal tax matters and a very limited class of communications with CPAs. Privilege can vanish fast. Here are the most common ways clients destroy it without even realizing it. Forwarding legal advice to your CPA that someone like me gives you. Forwarding it to your bookkeeper or business partner. Unless that person is retained under what's called a Kovel agreement, you just waive privilege. Letting a non-lawyer preparer join your IRS meeting. Their presence alone can break confidentiality. Claiming advice of counsel. Once you rely on your lawyer's advice as a defense, that advice becomes fair game for the IRS. Producing documents without screening. Once privileged material is voluntarily shared, that privilege is gone, no takebacks. Assuming there's a CPA, client privilege, there isn't, at least not outside Section 7525 and never in criminal cases. Here's how to do things right. Keep your attorney at the center of any controversy. Your lawyer should lead the engagement and, if needed, hire accountants through counsel under a Kovel agreement to make sure their work product stays under privilege. Separate return preparation from defense work. Legal strategy stays inside the privileged structure. Bookkeeping does not. Control written submissions. The IRS deserves facts, not your legal reasoning. Use privilege logs and stage reviews before producing anything. Document everything properly. Label litigation-sensitive work as prepared in anticipation of litigation. Some audits look civil on the surface but can turn criminal fast, especially when the IRS suspects willful conduct underlying any intentional noncompliance. In these high-risk eggshell or reverse eggshell audits, speaking directly to the IRS or going back to your original preparer can be so disastrous it could potentially land you in jail. These communications are privileged and can be used against you later. A properly structured, attorney-led Kovel team can keep your forensic accounting under privilege and your strategy insulated. When an IRS exam turns sensitive, every word matters. At the tax law offices of David W. Klasing, our dual licensed tax attorneys and CPAs work your case from its outset under the protection of attorney-client and work product privilege. When we manage the process, we safeguard your communications and endeavor to keep you out of the government's crosshairs. If you've received an IRS letter, an IDR, or audit notice, don't guess. And don't bring it back to your original preparer. Call us today at 800-681-1295 or visit klasingassociates.com to schedule a reduced rate initial consultation.